reading court documents, which means all of this that you would be listening to is basically the judge or the magistrate addressing the accused. His Honor, Stuart Leslie Lee, you have pleaded guilty to the murder of Colin Bainbridge, an entirely innocent and blameless man who provided absolutely no provocation to you for your murderous attack upon him. On 14th March 2023, you brought about the death of Mr. Bainbridge by throwing petrol over him and deliberately setting him alight with a stove lighter. Your plea of guilty was entered and accepted on the basis that your intention at the time you set Mr. Bainbridge alight was to cause him real serious injury. It was conceded on your behalf that there would be no distinction in sentencing you between an intention to kill and intention to cause really serious injury. But apparently, the distinction is important to you. The use of fire as means of inflicting serious harm upon another is shocking and heartless conduct. Mr. Bainbridge's son, Joshua, was working with his father on the occasion in question and observed you, as in the accused, set fire to Mr. Bainbridge. Joshua ran to his father's assistance and with great difficulty and after some time was able to douse the flames. He then waited with his father for the arrival of ambulance officers. The horror, anguish and devastation to which your conduct exposed Joshua was extraordinary and the effects will be lifelong. So too will be the devastating loss and pain suffered by all of the family and friends of Mr. Bainbridge. The pain and anguish you caused to Mr. Bainbridge himself as he awaited what he soon would have realized was his inevitable death is incalculable. According to what I, when I say I as in his or her honor, have been informed during the plea hearing whilst in recent times, you have expressed some regret for the death of Mr. Bainbridge, and you still assert some justification for your actions in spite of the fact there was not the slightest justification, and even now, 2 years after the event, you are entirely lacking in remorse. These few introductory words are sufficient to clearly demonstrate that your crime was of a very high order of seriousness and can only be properly met with very severe punishment. Now, following are the facts. Colin Bainbridge was 66 years of age at the time of his death. He resided in Wheatsheaf, a small rural location near Daylesford. He lived with his wife Anita Bainbridge. He had 3 adult children, Claire, Luke and Joshua. He was a cabinet maker by trade and was the owner-operator of Bainbridge Fine Furniture, where he worked with his 2 sons. He also engaged in land clearing and tree felling works in the local community. Mr. Bainbridge entered into an arrangement with your neighbor to conduct land clearing and tree felling at a small rural property in Wheatsheaf. This was to include the removal of a large tree branch which had fallen towards the fence separating the property from yours at which you resided. Mr. Bainbridge and Joshua commenced work at the property on the morning of 13th March 2023. They worked throughout the day using a bobcat and chainsaws. During the day, you were observed by Joshua to be seemingly hanging around near the dividing fence separating the 2 properties, raking leaves but behaving in a manner which led Joshua to believe you were keeping an eye on them. In a conversation you had with Francis Gurin, a local resident, in the middle of the day, you expressed your anger and resentment towards the owner of the property next door and the clearing work which was going on there. The work was not completed that day and Mr. Bainbridge and his son had to return the next morning to continue working. They worked on the property from about 10 a.m. with Mr. Bainbridge and Joshua carrying out different tasks some distance apart from each other. Mr. Bainbridge worked with an excavator with a claw attachment to lift a tree which had fallen on the boundary fence and then used a chainsaw to cut it up into manageable lengths. Joshua worked with a bobcat and chainsaw about 35 meters away. Sometime between 10 a.m. and 10:14 a.m., he heard the noise of yelling emanating from his father's worksite, and the chainsaw operated by his father stopped. He ran towards Mr. Bainbridge's worksite and observed his father standing next to the boundary fence with his chainsaw off and on the ground in front of him. Mr. Bainbridge informed Joshua that you had yelled out to him words to the effect of, "Get the F out of here" or "F off back to Melbourne." Mr. Bainbridge told Joshua that he had told you to F off. Mr. Bainbridge said not to worry about what had occurred as you had run off. The 2 men returned to their work. In the meantime, you ran to your home between 10:14 a.m. and 10:17 a.m., made 5 phone calls to the Daylesford police station using your mobile phone. The calls were unanswered. At 10:17 a.m., you again ran Daylesford police station on the occasion. On this occasion, the call was diverted to Bacchus Marsh police station, and answered by leading Senior Constable Roy Irwin. The phone connection was poor, you sounded hysterical, which made it difficult for Irwin to understand you, but he heard you yell, "V Chief," and "I need police here now." Irwin asked for your name and you told him. He told you to call 000 if you needed immediate assistance. You responded with the words to the effect of, if you're not coming, I'm gonna go and murder my neighbors. Before hanging up, the call lasted 3 minutes. You then went to your garden shed and picked up a blue bucket, intending to fill it with petrol. Realizing you would need something to light the petrol, you went inside your house and obtained a red gas lighter. You returned to the shed and poured a quantity of petrol from a red fuel container into the bucket. You immediately proceeded towards Mr. Bainbridge's location, carrying the bucket and lighter. You climbed over the fence, moved towards Mr. Bainbridge. Seeing you, he stopped chainsawing and left the idling chainsaw lodged in the tree. He faced you and told you to F off. You immediately threw the bucket of petrol over him, dousing him. You ignited the lighter and set Mr. Bainbridge on fire. In the process of setting Mr. Bainbridge alight, your right arm also caught alight. You immediately ran towards your property. You dropped to the ground to extinguish the flame on your arm. You dropped the bucket and lighter. You fled across the boundary fence and returned to your home. Your attack upon Mr. Bainbridge was witnessed by Joshua, whose attention had been caught by the sound of yelling. He saw you throw the fuel, and as he sprinted towards you and Mr. Bainbridge, he saw his father go up in flames screaming. Joshua took off his jumper, which he used to try to extinguish the flames. This was not successful, and at Mr. Bainbridge's suggestion, Joshua ran towards the house to get a garden hose. Followed by Mr. Bainbridge, he used a steady stream of water to extinguish the flames and then stayed with his father to comfort him and await the arrival of paramedics. Joshua observed his father to be lucid. Mr. Bainbridge said to Joshua, "I can't believe this bastard has done me in." Joshua used his father's mobile phone to contact emergency services. You called Dalesford police station twice using your mobile phone at 10:22 a.m. before calling 000 a couple of minutes later. You gave your name and address and requested police attendance. You told the call taker, "I have had trouble with my neighbors. I threw petrol over the people on the property next door and I lit him in flames." Fire. You claimed that you had been just defending yourself and said that Mr. Bainbridge would need an ambulance urgently. Ambulance paramedics arrived at the scene at 10:42 a.m. Mr. Bainbridge was sitting on the ground outside the house at 150 Wallaby Road being cared for by Joshua and a CFA member who had been attended. Mr. Bainbridge was seen to have full thickness burns to 80% of his body and airway burns. He was transported to the Alfred Hospital by helicopter. Police attended at your property and arrested you at 11:45 a.m. You asked for treatment to your burned right arm. You spoke to police and the conversation was recorded on a body-worn camera. During the conversation, you said that Mr. Bainbridge had threatened you with a chainsaw and you decided that you would try to stand up for yourself. You claimed that he had told you to F off whilst waving his chainsaw at you and revving it. Your only option to defend yourself, you said, was to use petrol. You had rung back as masked police and begged for help, but been asked to call 000. When you realized police were not coming or going to help you, you resorted to your only option, you claimed. You admitted obtaining the bucket, petrol and lighter. You admitted jumping the boundary fence and approaching Mr. Bainbridge. You said you threw the petrol on Mr. Bainbridge from about 2 feet away and lit the fuel using the lighter. The facts of your crime were set out in the amended summary of prosecution opening for plea. The SPO was accepted by your counsel, Mr. Munster and Mr. McGlone, to be an agreed summary. As the SPO made clear, your claim of having been threatened by Mr. Bainbridge with the chainsaw was false. In fact, at the time that you threw petrol over Mr. Bainbridge, he was in the process of completing his lawful tree clearing work and his chainsaw was lodged in a tree. The examination of the crime scene by police revealed the presence of melted bucket you had used to throw the petrol over Mr. Bainbridge and the lighter you had used to set him alight. A 5-liter red fuel container with the lid removed was found in the front of the doorway to your garden shed. During assessment and treatment, the Alfred Hospital, Mr. Bainbridge's injuries were noted as following. A. Mixed thickness between burns involving 80% of the total body surface. B. Full thickness burns to almost all of his anterior and posterior trunk. Mid/deep dermal and full thickness burns to the entirety of both upper limbs. Lower limbs circumferentially involved from knees down and near circumferentially above the knees. burns to the face involving roughly 4.5% and will progress further. And perineum largely spared some involvement of bilateral buttocks. Medical staff at the Alfred determined Mr. Bainbridge's burns to be unsurvivable due to their extent. He was transitioned to the palliative care unit for end-of-life care. He was declared deceased at 10 p.m. on 14th March 2023, a little less than 12 hours after your attack upon him. You participated in a police interview on 14 March 2023. You exercised your right to make no comment in response to most questions asked of you. However, you gave the following relevant answers. You had no intention of murdering anyone. When told that Mr. Bainbridge was in hospital with burns to 70% of his body, you responded, I'm sorry for this situation. You knew who Mr. Bainbridge was, having met him once many years ago. He was a local. You did not know his name. You knew that he did not reside next door to you. And you were sorry for all the stuff that you were at police station for. Now, the court document sheds a little bit of light on the personal background of the accused. Stuart Leslie Lee, you are 65 years of age. You were born in Melbourne and brought up in Essendon, where you lived with your parents and older sister. Your father ran a hamburger business and your mother was a stay-at-home parent. You were educated to what was described on your behalf as a rudimentary level at Essendon Primary School and then Strathmore High School. With your parents' encouragement, you left school after completing year 9 to seek paid employment. You were not strong academically at school but obtained some proficiency in music, learning the flute, which enabled you to pursue an interest in community brass bands as an adult. Your father was a strict disciplinarian, and on one occasion, you were young. After he had violently assaulted you, you contacted the police. Your father was not charged, but you were not further assaulted. Upon leaving school in hope of becoming a jockey, you worked with a horse trainer in Cranbourne. You lost your job when your employer lost his trainer's license. You then worked in factories for several years before being made redundant after suffering an epileptic seizure at work. You then worked for Melbourne Water for over 10 years in various roles, including as a storeman at Brimham Park and then at the depot in Sunshine. In the mid-1980s, you resigned and received a payout which you used to part-fund the purchase of a 5-acre bush block in Wheatsheaf. You had one significant relationship in your life with a woman named Julie. You met her when you were both in your teens. The relationship ended shortly after the birth of your daughter Melissa in 1980. You became Melissa's sole carer. You lived with her in Melbourne until she was about 5 or 6 before moving to Wheatsheaf property. Initially, you lived in a caravan on the property before moving into a newly built home. Melissa attended school in Daylesford. This was a positive and stable time for you. You found meaning in being a father and established a positive relationship in the community. After Melissa completed her schooling and left home, you struggled to adopt life without her. Your mental health deteriorated, as did your relationship in the community. A letter from your daughter Melissa was tendered on your behalf during the plea hearing. It set out in detail her contact with you over the years, her current level of contact with you, and her perception of your declining mental health in recent years. A letter from your friend and cousin once removed, Bruce Watt, was also tendered on your behalf. I've had regard, I as in your honor, is saying this, have had regard to the contents of both these letters. Forgive me, I mean his or her honor. During your positive years in Wheatsheaf, you were employed in a horse trail riding business in the Daylesford area before suffering a knee injury. You were then on disability support pension for 20 years, leading up to your arrest on the current charge. You served in the Army Reserve and volunteered with the State Emergency Service. You have been estranged from your father and sisters for many years. Your driver's license lapsed in 2015 and was not renewed. Since that time, you have walked between Wheatsheaf and Daylesford on a nearly daily basis to purchase your food and other necessities, and have otherwise rarely left the police area. Have rarely left the local area. And then there's some detail about the physical and mental health, and then there's a bit of detail about the criminal history. Your criminal history is very limited but highly relevant. You were convicted at Ballarat Magistrate Court in 2021 on a charge of making a threat to kill. You received a without conviction adjourned bond for this offending. The incident in question occurred on 13th October 2020 when you became very agitated as a result of your brother of your next door neighbor on the other side, David Bull, with the knowledge of the owner, depositing some rubbish on the property. You approached Mr. Bull in a highly agitated state and stated that you would throw petrol over his car and set it alight on the same naming. You called 000 and reported that your neighbor was dumping rubbish and that you would kill him if police did not arrive within 10 minutes. You said you would get a bucket of petrol and throw it over the neighbor and set him on fire, killing him. Later on, the owner of the property, Laurie Bull, arrived home and heard you yelling outside about wanting justice. You said you would kill someone if they came onto your property. You had with you a bucket with petrol inside it and matches and a gas lighter in your pocket. When the police arrived, you yelled at them not to approach you and said you would kill your neighbor if you did not get justice. At a later police interview, you were cooperative and made full admissions. In explanation for your threats, you said you were frustrated at making reports to council and the police and not getting justice. There were 12 victim impact statements that were filed in this case. The statements were by Anita Bainbridge, wife, Claire Finn, daughter, Joshua Bainbridge, son, Luke Bainbridge, son, Robin Bainbridge, sister, Janine Bainbridge, sister, Meryl Bainbridge, sister, Vivian Bainbridge, mayor, sister, Stephen Bainbridge, brother, Sarkis Aznavourian, friend and co-owner, Laurie Aznavourian, friend and co-owner of one of the properties involved. There is address mentioned, but I'm intentionally not mentioning it to respect their privacy. Ms. Finn and Joshua Bainbridge's statements were read by the respective authors. Ms. Ellis, who appeared with Mr. Burke Casey for the prosecution, then read the statements of Luke Bainbridge and Mrs. Aznavourian. The remaining statements were not read aloud in court. I, as in his or her honor, have had regard to the contents of all the victim impact statements. During her plea, the mitigation on your, as in the accused's behalf, Ms. Munster, who appeared on your behalf with Mr. McGlone, appropriately noted that Mr. Bainbridge's loss is a tragedy for all who knew him and loved him. She acknowledged the courage and suffering of the victims of your crime and correctly described the victim impact statements as heartbreaking. And I'm just going to go through some of the more details because there's just too much detail to it. And then I'm coming down to the plea of guilty. Now his, her, or her honor state that you entered your plea of guilty on this charge on the 12th February 2025, shortly after the case conference which was held in this case. Until that time, your case had been listed for trial and your defense, as indicated in the defense response, was lack of murderous intent. You had offered to plead guilty to manslaughter sometime before the case conference, but not surprisingly, that offer was rejected. Ms. Munster, I'm assuming that's the lawyer or the attorney representing the accused, submitted that your plea of guilty should be considered to have been entered relatively early. Whilst acknowledging the absence of remorse in your case, she submitted that your plea of guilty facilitated the course of justice and saved considerable resources and had considerable utilitarian value. Now, his or her honor then further stated that I do not accept that your plea of guilty should be considered to have been entered relatively early. You were charged in murder on the 14th March 2023. Almost 2 years passed before your plea of guilty, during which time you were maintaining your innocence of murder. The case had been set down for trial in March 2025. Preparatory cross-examination had been conducted on your behalf of a witness, including Joshua Bainbridge, the son of Mr. Bainbridge, and an eyewitness to your crime. Your continuing denial of guilt for almost 2 years after your crime no doubt caused the loved ones of Mr. Bainbridge ongoing anxiety and distress. And then I, as in his or her honor, do not take into account your plea of guilty and the time at which it was entered. There was some utilitarian value to the plea, including the saving of substantial resources required in conducting a trial in this court, and belatedly some easing of the ongoing pain and concern of the family members of Mr. Bainbridge. I, as in his or her honor, take these matters into account in your favor in your case. The weight to be attributed to your plea of guilty, particularly in the light of the absence of any remorse, is not as great as would often be the case. Having said that, the Section 6 AAA declaration, I, as in his or her honor, will make in passing sentence upon you, will make it clear that I have significantly reduced your sentence in the light of your plea of guilty. Again, in this document, wherever it's I, it's basically his or her honor, the sentencing judge addressing him or herself. In respect of the obvious lack of remorse in your case, I note that the absence of remorse is not an aggravating feature, but rather represents the absence of what might otherwise have been a significant and mitigating feature. Now, nature and the gravity of the offending. Miss Munster submitted on your behalf that objectively grave though your crime was, it was a crime and the objective circumstances of which are in the middle of the range of seriousness. In support of the contention, she noted many possible aggravating circumstances which were not present in the case. The somewhat optimistic submission of your counsel as to the objective seriousness of your crime can be readily rejected. The recitation of some aggravating features of your offending set out in Miss Munster's own written submissions, along with other matters already dealt with in these reasons, indicate that your crime was towards the very upper reaches of the spectrum of seriousness. As submitted by the prosecution, you made a deliberate and calculated decision to initiate an entirely unprovoked attack upon Mr. Bainbridge. Your attack was aggressive, incredibly violent and ruthless. The manner in which you chose to attack your completely innocent and unsuspecting victim was fairly described by the prosecution as barbarous. And then there's a reference of another case given and some text from that. Mr. Bainbridge remained conscious throughout the horrible ordeal you deliberately inflicted upon him, and for some time thereafter, and no doubt experienced great pain and emotional sufferance as he lived through these remaining hours. The absence of some of the possible aggravating features in this case of your crime, as outlined by Miss Munster, says nothing all about the seriousness of your offending. Your crime is to be judged on all of its circumstances, including aggravating circumstances present, rather than on the basis of these circumstances which are absent. On any sensible analysis, the circumstances of your crime dictate its extreme seriousness, and it could not possibly be considered to be in the middle of the range. It is right towards the very top. Now, murder is a Category 1 offence pursuant to Section 3 of the Sentencing Act 1991. Section 5, subsection 2G of the Act requires the sentencing court to impose a term of imprisonment when sentencing for this crime. And then there's heading of standard sentence scheme. As your crime was committed after 1st February 2018, the standard sentence scheme applies to the offence of murder of which you have been found guilty. The standard sentence of murder is 25 years. Pursuant to Section 5A, subsection 1, subsection B of the Act, the period of 25 years is the sentence for an offence of murder. That taking into account only the objective factors affecting the relative seriousness of that offence is in the middle of the range of seriousness. And then there's a reference of another case. I've had regard to the I as in his or her honour, have had the regard to standard sentence of the murder as one of the matters to be taken into account in arriving at the appropriate sentence for you on the charge of murder by the process of instinctive synthesis. In doing so, I as in his or her honour have applied the law explained in Brown. Brown is a reference to another verdict. And then his or her honor said that I have endeavoured in these details reason for sentence to comply with the requirements set out in Section 5B, subsection 4 and subsection 5 of the Act. In arriving at the sentence, I will shortly pass upon you, as in his or her honor. And then I can indicate that I have taken into account all of the matters I'm required to consider Section 5, subsection 2 of the Act, including the standard sentence of murder. I've taken into account any mitigating factor which apply to crime by the process of instinctive synthesis. I've arrived at the sentence I will announce. And then there's some more details. I'm just going to quickly skip those. And then it's the sentence. Stuart Leslie Lee. Normally in these documents, when I read, the judge would ask the accused to stand up. I'm assuming it was mentioned, but not in the document, but generally they asked to stand up. I'm assuming they would have done it this time. Stuart Leslie Lee, for the murder of Colin Bainbridge, you are sentenced to be imprisoned for 35 years. I, as in his or her honor, fix a period of 27 years during which you will not be eligible to be released on parole. Our thoughts are with the deceased, the victim, and their loved ones.